So this is online lecture 3 on the Establishment Clause. This is to supplement what we will discuss in class this week on the Establishment Clause. So really it picks up after Lemon v. Curtman. So remember, the Establishment Clause is that second part, or really the first part of the First Amendment religion protections, that Congress shall make no law respecting an establishment of religion. So in class we discussed this overview, we discussed Everson versus Board of Education, and we discussed Lemon versus Kurtzman and introduced the Lemon test. As a reminder, the Lemon test, in order for a law to pass muster, in order for a law to be constitutional, it must have a secular legislative purpose. It must, in other words, not be aimed at religious purposes. The law's principal or primary effect, so we're setting aside purpose, effect must be one that neither advances nor inhibits religion. And the statute must not foster an excessive government entanglement with religion. So we anticipate that some entanglement will happen, but not an excessive entanglement. So that brings us to our cases that come after Lemon, like Aguilar and Agostini. So we're going to see a lot of school cases today, and the Aguilar and Agostini cases are school cases, and they're related cases. So this has to do with Title I funding again in New York schools. And in 1985, we have the Aguilar v. Felton case, and this struck down a program that allowed state-funded remedial instruction of students in private schools. In other words, the states weren't just sending workbooks, but they were sending teachers from public schools into private schools to tutor or otherwise provide remedial instruction for private school students. And these were students who needed remedial instruction and qualified under Title I. So the Supreme Court struck that program down as violating the Lemon test. They said as soon as you put a public school teacher in a private school, that is excessive government entanglement. And so the state of New York decided to get creative. And what they did is they bought lots and lots of vans, big, 10, 14-person passenger vans. And they retrofitted them in ways that would allow public school teachers to drive on public roads up to the point of the religious school, so they would still be on public grounds, public roads, etc., park the van, and students would come out to the van and get their remedial instruction there. As your book notes, they spent over $10 million on buying and retrofitting these vans. It was an extremely expensive process that actually ended up draining most of the money from the available funds. So there weren't a whole lot of funds to actually provide the remedial education. In between 1985 and when the Agostini case started in 1995, wasn't decided by the Supreme Court until 1997, a few cases came out that suggested that the court might be willing to look at the Aguilar program again. And so the Agostini case is not challenging the van program directly. The van program was not really at issue here. What's at issue is the same thing that was decided in Aguilar. But what they said is whether they were suing based on this idea that too much money was being spent and wasted on the new program, and that provided a violation of the Title I rights of these students. So really, they're redeciding the same case they decided in 1985. The two major changes that they point out in the decision, and that were pointed out to them. One is that cases signaled that they abandoned the presumption that the Establishment Clause is violated when you put public employees in private schools. So that in one case, a deaf student who needed an interpreter was allowed to get that interpreter through publicly funded dollars, even though that student went to a private religious institution. So we no longer have this kind of bright line rule the minute a public school teacher steps onto private school grounds that there was some sort of violation. Two is they departed from the rule that government aiding religious education is somehow invalid. So there is there is funding available for blind and deaf students that is not available for non-hearing impaired or sight impaired students. And some of this funding was allowed, in one case, to pay for a blind person's attendance at a religious seminary. So with these two major changes in the law, the court said that Aguilar is no longer valid law. In other words, the program as it used to exist before they spent $10 million in vans, was okay now. So they said that it does not mean that it's a per se violation to put public school teachers on private school grounds. And the reason why they say that is they argue that as long as there are safeguards in place when the public school teacher enters the private school grounds, that this is not excessive entanglement. And the dissent essentially throws its papers up in the air and says this just opens the floodgates for entanglement to happen. That if you have public school teachers being asked to go onto private school grounds, religious school grounds, the fact that they're teaching remedial math does differ when they're teaching remedial math under the picture of a pope. So the dissent was very concerned about this. And they certainly weren't the only ones. There were a lot of public interest groups that were concerned about this as well. Another hot button topic that hinges on the Establishment Clause is this idea of school vouchers. So there is a political idea that if parents want to send their children to private school, particularly because the public schools in that area are failing, that they should be provided money, either equivalent to or some fundage, to send their child or children to private schools, regardless of the fact that these may be religious institutions. And the special facts of this case are important. As you'll see in many cases, this isn't a blanket statement that school vouchers are okay. This is a statement that school vouchers in this instance are okay. So you have the Cleveland school system, which was failing pretty significantly, much like the Detroit school system is failing now. And so because of the failure of the Cleveland school system, the Supreme Court took these facts differently. And the facts are this. The state set up a program whereby students in the Cleveland public schools, when they attended high school, could choose to do one of a number of things. They could simply go to school, come home, never accept any additional funding or help or aid. They could request supplemental instruction or tutoring up to a certain amount of money to supplement what was deemed to be failing schools. They could also request vouchers of a certain amount of funding to be sent to a nearby public school in a different district, as long as that district signed up for this program to accept students. And then there was a second voucher program for private schools. They could be religious schools. That would also be a voucher program. None of the public school districts in the area signed up for the voucher program that was open to public schools. So that was not an option. The only options were doing nothing, getting the tutoring, or going to a private school, almost all of which were religious schools. And so the question becomes whether this scheme is a violation of the Establishment Clause. Is it a violation of the Establishment Clause for the state of Ohio to provide vouchers for private religious education? And the court in 2002 said no, this is not a violation of the Establishment Clause. Where a government program is neutral with respect to religion and provides assistance directly to a broad class of citizens who direct government aid to religious schools as a result of their own private choice, the Establishment Clause is not violated. So essentially what they're saying is that the added benefit or deterrent or just the added fact that you're getting religious education on top of the neutral math, science, etc., is secondary and not of concern. As long as the government aid is neutral and they are not picking one religion over another, then you don't have an Establishment Clause violation. Now, it's important to note you have two attempts to pull this back a little bit. So you have O'Connor concurring in the result, but saying that the reasoning that the court gives actually tends to open the floodgates to more cases. So that really all you need to determine is whether the program administers aid neutrally, so that it doesn't determine Christian schools get this money but Jewish schools do not. And so that was met here. And that whether the beneficiaries actually have a genuine choice among religious and non-religious organizations in determining where to direct that aid. And so that means you have to have some non-religious schools in the pool as well, and that you have to have a mix of religious schools. And because Justice O'Connor felt that that mix between non-religious and other religions was sufficient, that the decision of the court was acceptable, but the reasoning, which seems to kind of do away with the Lemon Test or at least ignore it altogether, that is acceptable as a program. It should be noted, though, that the dissent does not feel this way. The dissent says this is a wholesale violation of the Establishment Clause, that the court is bending over backwards to allow this to happen, and they are allowing it to happen for political reasons, and that this is not a good interpretation of the Establishment Clause. But as of now, it stands. So one other aspect of public school, or just schooling in general, education law, is teaching religious principles in public schools. So we're not talking about going to private school, but going to public school. You may be familiar with the Scopes Monkey trial. That was a case in Tennessee, and the cases we're going to be talking about are not in Tennessee, but are very similar. So the Epperson case was a 1968 Supreme Court case, which, if you notice, the Scopes Monkey trial took place in the 1920s, so this was long after that. And the Epperson case invalidated an Arkansas law that made it a crime for any public school teacher or university professor to teach evolution to their students in their classrooms. So this was a law that was on the books for quite some time, and was invalidated by the Supreme Court. The Edwards versus Aguillard case in 1987 shows an attempt by certain states to try and revive the debate between creationism and evolution. And so you have this case about the Balanced Treatment for Creation Science and Evolution Science and Public School Instruction Act of 1981. And what it did is it required teachers who were going to teach evolution to also teach creationism, give it equal airtime. Despite the fact that the science is not exactly equal on those two matters. And Aguillard, who was an assistant principal at a school that was covered by the act, and some teachers filed suit along with the help of the ACLU. And the issue here is very simple. Whether this law violates the Establishment Clause, whether this shows a government preference for certain religious beliefs. And the court says, yes, this certainly violates the Establishment Clause. And what's interesting here is you have the court looking at the legislative history behind this law. And the legislative history behind this law was not that you should give equal time to valid proposals or two valid theories, or even scientifically backed theories or theories in general. If you read the legislative history, the legislative history was pretty clear that they were doing this because they were not allowed to directly mandate that creationism be taught. So they were pretty much saying this is a backdoor to have creationism taught in our schools. And so the court said, we're normally deferential to the states. We normally say, states, do what you want to do. But when the states say in the law, hey, we're doing this to give equal airtime, but then you look at the legislative history and it's clear that that's not the case. And if it is clear that the purpose is only to teach a religious principle like creationism, then that is not going to be allowed. Another interesting note for those of you who follow the court, Scalia dissented and asked to look at legislative history, which is not something he usually likes to look at. So, interesting fun fact there. Now, prayer in schools, and you have on the right there the joke that every dad makes at every dinner table about as long as there are tests in schools, there's going to be prayer in schools. A lot of people claim that there is not the ability to pray in school. That is not true. What is true is that schools cannot set aside time or preference for prayer in specific ways. So let's break this down a little bit. You have the Engel case, which invalidated a New York law that required teachers to read aloud and lead students in a certain prayer that was written by the State Board of Regents. And the court said, no, we're not going to approve of this. This is definitely a violation of the Establishment Clause. Not only are you requiring school children to recite this prayer, not only are you requiring teachers to lead them in it, but you are writing the prayer for them. There is nothing that is more blatantly anti-Establishment Clause than this. The next case, the School District of Abington Township versus Schempp case, or the Schempp case, is whether having students be required to recite prayer or Bible verses violates the Establishment Clause. Now, you can claim that the Bible verses are neutral, but when you're reciting them as opposed to studying them as a piece of literature, that becomes a religious exercise. And so the court said because these exercises have a religious character, they are impermissible under the Establishment Clause. What was interesting is that the school was trying to claim everybody in the school is Christian, and so therefore it's okay. But the court says just because you are in the majority, even a supermajority, doesn't mean you can impose your views on the minority, even if that minority is not existing in every room. So the public context is what matters here. The dissent said, well, any student can just walk away from the prayer. It's not required. But just because you're not being required to actually recite it out loud, being required to sit and listen to other people do it, it is kind of a choice that a child should not have to make. The majority didn't agree with that. The Wallace versus Jaffrey case invalidated an Alabama law that required a daily period of meditation or voluntary prayer. So they would essentially have an extended moment of silence, and the court said, try again. We're not going to approve of this either. What becomes an issue more than prayer within the school bells, within the context of the day-to-day school activities, is what happens during non-classroom times. The Lee versus Weissman case is such a time. This is whether prayer at a non-mandatory public middle school or high school graduation violates the Establishment Clause. And the Supreme Court said it does. Now, what's interesting here is you have a graduation ceremony where the graduation ceremony is not mandatory. You don't have to show up to the graduation ceremony to get your diploma. In fact, at most graduation ceremonies, you don't even get a diploma. You get a fake diploma. But they were giving whoever provided the prayer a pamphlet about what was an appropriate prayer at this gathering. So there is a bit of entanglement here, right? And the interesting thing is, even though it's not mandatory, that doesn't mean that it's not important and that they can just go full force with the prayer. So, what had happened in this case, interestingly, is that at the high school graduation, the Weissman's daughter was participating, the eldest daughter, and she had to participate while hearing the prayer. And the father, on her behalf, claimed that this was a violation of the Establishment Clause, as they were Jews, and the prayer was offensive. But if you have paid attention to that supplemental lecture I did, that presents a standing problem, because after she's graduated, she's never going to have to sit through graduation ever again, and therefore the case is moot. However, the courts kept the case alive based on the fact that the younger sister would eventually have to sit through the same or similar graduation speech during her own graduation. So they really used the younger sister and not the eldest one as the child at issue here. But that aside, what the court said is you cannot put children in the place of having to choose between participating in prayer or an activity that supports prayer, or somehow protesting the activity, when it's something as important as graduation. Scalia dissented, as he does quite often, and says this isn't mandatory. The prayer was not indicative of something that would be too heavily biased, so they should be okay. But the court didn't see it that way, and they invalidated prayer at high school graduation. And in Santa Fe Independent School District versus Doe in 2000, the court invalidated a practice of a district that would allow students to hold prayer before football games on the field using the PA system. Although the school said, it's just the students that are doing this, it's not us. The court said, yeah, but you're letting them use the space and the time and the PA system, and therefore this is not acceptable under Establishment Clause standards. Finally, we have the issue of whether or not public places outside of public schools can have some religious descriptions, events, or depictions. And one of those issues tends to be religious depictions in holiday situations. So a creche is the scene of the manger and the baby Jesus and Mary and Joseph. And the Lynch versus Donnelly case said that a public entity could have a creche where it was one part of a holiday display. So if you have a creche and then you also have a snowman and, Santa and the reindeer and all of that, as long as it's just one part of a holiday display, that's okay. The County of Allegheny versus ACLU case said that, however, it is a violation where that creche is placed in a prominent place and everything else is kind of hidden and out of sight. So if you have a giant creche, tiny snowman around the corner, that's not going to balance it out. What's interesting about this is that most local entities seem to violate this despite these rulings being in place. I know of several around me where the display of the creche is pretty large in comparison to the other things. And it just seems kind of out of place. But as of now, you still can display it. The Stone versus Graham case struck down a Kentucky law that required the Ten Commandments be posted in every classroom as a violation of the Establishment Clause. However, we get to Van Orden versus Perry. And Van Orden versus Perry, what is at issue here is a fairly large, about a 6 or 7 foot tall statue of the Ten Commandments that was present on the Texas State Capitol grounds in Austin, Texas, and is still present. And the court was asked to decide whether or not this monument violated the Establishment Clause. And the court said No. Now, you may be saying, the court said what now? Yeah, it does seem a bit counterintuitive given everything we've discussed. It doesn't seem too far-fetched that someone might misinterpret government establishing or preferring a certain religion, or at least a certain set of religions, if they have the Ten Commandments on government grounds. However, the Van Orden versus Perry case says otherwise. And it said, because Texas claimed that the monument was meant to depict the historical influence of the event of Moses handing down the Ten Commandments, and that the Ten Commandments were part of Texas's history in that it was built on those values, that it was okay to have Texas display the Ten Commandments on the Texas State Capitol grounds. Now, I want you to actually see what this thing looks like. One of the claims that the state said is that there are a variety of statues on the state capitol grounds that depict different things in Texas's history. But I'll let you be the judge.
Well, this is the Ten Commandments monument that was at issue in the Supreme Court case of Van Orden. You can see it's surrounded by no other monuments. This is the Texas State House grounds. There are other monuments elsewhere that are out of sight, but this stands alone right here. It's a pretty unimportant part in the back, but it obviously is right next to the State House, you can see here. Now, I want to point out a couple of things on this monument. You can see how tall it is. You can see that you got this eye, which I don't think really has anything to do with the Ten Commandments. Also the eagle, and the American flag. How Ten Commandments related is that? And I don't know which way that cuts in terms of what the law should be. It's just not that religious. If it represents the history of law, there's a better reason for it to be acceptable on state property, considering that the state isn't supposed to establish religion. So the more it seems like it's governmental, the more it's not an establishment clause problem. So the eagle and the flag and the old eye that's also on the dollar bill, although I don't know what religion that represents, that all helps it be more acceptable in terms of the establishment clause. But by the same token, people who are religious maybe ought to be offended by this. Does this really belong here? Should it be next to this government building? Should you have an eagle? Is it not a sacrilege to have an eagle on the Ten Commandments? Is it a sacrilege to have a law professor pointing at it and complaining about it? Maybe it is. So, let's not... Let's not be too critical of the poor state of Texas that put this here, and I don't think they should take it down, but I think the most American thing about it and the least religious thing about it is just that it's so thoroughly ridiculous.
So, interestingly, the person in that video is Professor Ann Althouse. She's a professor and a blogger, a law professor. And as you can see, that monument is not like in a path that talks about the history of Texas. It's not saying anything on it that Texas is putting this there because it is what Texas law is based off of or anything like that. It's just kind of a mixed bag of imagery. But it is the Ten Commandments. However, the court thought it was okay. No word on whether the court actually visited the grounds to see it. I would venture to say most of them have not. But there you have it. So take that for what it's worth. Now, this case has led to many groups protesting and getting their way in displaying other religious artifacts in public places, like perhaps an 8-foot-tall statue of the devil, which is being provided to the people of Oklahoma by a group. Or in Lansing, there was a display that was put up by a local satanic group to coincide with Christmas. I think they did it again this year, but it's been done in the past as well. So you can't prefer one over the other. So you're going to get this if you allow one. One other case that we should talk about that is not in your book is a more recent case. It's the Town of Greece versus Galloway case, a 5-4 decision that came out in 2014. And the issue is whether a local town board could start each meeting with a prayer from a different clergy member. So it wasn't a prayer from a member of the board or from a member of the public, but it was very specifically a member of clergy. And people challenge this practice because this is an open meeting of a public entity. Should it start with a prayer? Well, the court said this didn't violate the Establishment Clause. This is why. One, Congress and state legislatures start their sessions with prayers all the time. And so if it's okay for Congress and state legislatures, it's okay for the town of Greece. Two is that they said they were willing to have any religious officials come in, any clergy members, and give a prayer, that they weren't discriminating against one over another, and therefore it should be allowed. And then finally, there's no coercion to actually recite a prayer. It's just kind of an invocation, and therefore no one is being compelled to do anything. But this is a 5-4 decision, and these cases quite often are 5-4 decisions. So what you should note about some of this is how precarious some of these decisions are. That even though they're good law now, they might not be in 5 or 10 years. And depending on your view of religion, these might be more or less offensive to how you see the world. So these Establishment Clause cases are they're very important to how we define a country based on freedom of religion.